I'm J. Jermaine Bay of Melodium Morris Pradium, Monte, Colorado. The acronym is AMPAC. I'm the Chief Judge across the court. Today is Class 118. Class 118. What do we learn in Class 117? Well, what we started doing is looking up the definition of words such as Morocco, right, in an etymology online dictionary. And what do we find out when we looked up that word? Well, the word actually recognizes the word Morocco, Moroccan, and Moor, all in the same dictionary, right? So what should we take away from that? Well, the reality is on the etymology, right? And we understood about the etymon, right? If in fact Morocco, Moroccan, and Moor are all in the same definition, that's called what? A synonym, right? So therefore they make no distinction between Moors and Moroccans. Well, if that's the case, then why do Moors keep calling themselves Moorish Americans? Well, it's because what we're saying out loud is that we're still naturalized people. We don't realize it, but we have accepted what's called a nom de guerre. And through that nom de guerre, saying we're Moorish Americans or that we're black people, what we're saying is we're still suffering from cognitive dissonance, whether knowingly or unknowingly. So all this time we kept saying we were Moors, especially for the Moorish Americans. They were cognizant to know that they were actually Moors. But they were still adding the surname, right, the adopted name of American on the tail end of that. The reality is your treaties say you have to choose between the entire submission to going back to your motherland, which is jurisdiction of Morocco. I'm talking jurisdiction. I'm talking layers. Or remain naturalized in the jurisdiction of America. Even though I'm talking in layers, right? Still talking soil, I'm still talking land, but the land can't speak for itself. You ever seen dirt talk? It can't talk. Who talks for the dirt? It's called a pen. And the people, through a competent instrument commonly known as a Constitution. And the Constitution is what sets forth the name of said land. And whoever names the land, the next question is, okay, is that person the sovereign? Or is that person claiming some internal sovereignty? What do I mean? Well, there's such things called external sovereignty, then there's internal sovereignty, such as the Indian reservations, right? Indian reservations have what's called internal sovereignty. They get to govern, right? They have the autonomous right to govern, to self-govern amongst an Indian reservation. That's internal self-determination. However, what is external self-determination? That is the sovereign that governs over all other internal states. And external states govern over all Indian reservations. External states govern under anyone else who's a dependency state, right? But the external person who has the Constitution is the sovereign, is the supreme. It is the supreme law of the land, commonly known as jurisdiction. And the question is, when Moors started studying, they should have been asking themselves, okay, what jurisdiction do Moorish Americans come under? Well, the question would have been no jurisdiction whatsoever under Moorish American, because there ain't no such thing as Moorish Americans. It's a fiction. It is a nom de guerre. It is color of law. It's color of authority. It has no legal force of law. Because the word Moorish American is not recognized as a political group of people. Moorish Americans recognized as a religious organization. And that's it. It's no different than saying you're Baptist. But it's certainly not a political group of people. You get to claim some type of authority of law as a political recognized people of a constitution that has 3 branches of government. Churches and temples can't get into relations with other states as if they're a state on state relations. No, a state can get in relations with a temple if it so chooses. But a temple can't pretend like it's a state. It has to identify itself as a temple. There's nothing wrong with a temple trying to get in relations with a state. But a temple can't say it is an actual absolute state. That's called color of law. That's color of authority. right? So what else did we learn in class 117? Well, we started reading over international treaty, commonly known as the responsibility of states for internationally wrongful acts of the year 2001, right? So we started reading it. We got down to Article 4, right? We'll pick up with that today. And what should we take away already from what we've started to read? Well, international law has set forth reforms, right, to allow states to now sue, right, have a tort claim against other states for what's commonly known as reparations. But you must understand the word reparations is a generic word. It doesn't mean money. It could mean just basic restoration, right? Can you just return something you took? That's reparations, to repair a loss, right? So reparations can be in the form of compensation, right? It can be restitution. It can be commonly known as satisfaction. If you just give me back what you took, we good. That's satisfaction. It can be in the form of interest. You can pay interest on top of the restitution, right? Or compensation. It's different things involved with reparations. Reparations doesn't always just mean money. It's different ways to perform a reparation. But the first obligation of reparation was on who? It was on us as a people. The reparation started with us. We have to repair our own status first. We have to repair, to repatriate back to the state. Only states can now request or petition for reparations. Stateless people cannot get reparations. So now that we have to repatriate back to the state, now we can apply for reparations because we repaired ourselves first under decolonization, the due process of decolonization. So as we start to get into the class, just understand, as we keep studying the responsibility of states for internationally wrongful acts of the year 2001, which is an international treaty for states to now bring suits against other states and other organizations, international organizations. This treaty came out in 2001. We must understand it's already been out for over 20 years, and the Moors had no clue. The black people had no clue, and all of us been trying to find a way to bring some type of suit against an injury to our community. But now we know. We're studying now how to go about acquiring reparations. But the first reparation, like I said, we have to repair ourselves. It'd be an impropria persona sui juris, which is being to statehood. All right? So, as you know, I always open up the class with our Constitution. Constitution is paramount, right? But today, I want to feature Nigeria's Constitution of 1999, right? As I continue to go on with AMPAC study session, I will have features, right, to show how other Moors on planet Earth already have constitutions, how they're already in statehood. They're following the customary norms of international law. They're studying the due process of international law. They're checking the boxes. They've already checked the boxes. You see, only the Moors in the West, with their arrogance, keep thinking they don't need constitutions. But that's a misconception, right? So today I'm going to feature Nigeria's Constitution of 1999. So what we'll do is we'll read the preamble, okay? See here. Nola, can you read the preamble?
Preamble. We, the people of the Federal Republic of Nigeria, have firmly and solemnly resolved to live in unity and harmony as one indivisible and indissoluble sovereign nation under God, dedicated to the promotion of inter-African solidarity, world peace, international cooperation, and understanding, and to provide for a constitution for the purpose of promoting the good government and welfare of all persons in our country on the principles of freedom, equality, and justice, and for the purpose of consolidating the unity of our people, do hereby make, enact, and give to ourselves the following Constitution.
All right, thank you very much. So it's the preamble of Nigeria's Constitution, right? Mm-hmm. So it says here, we the people of the Federal Republic of Nigeria. So what they're doing now is They're talking about the republic is we the people. The republic is the people. Right? And then they tell you the nationality is what? Nigeria. Right? So the Nigerians, right? Then it continues to say, have firmly and solemnly resolved. Right? What does resolve mean? They fixed the problem. Right? They repaired their own status. They were colonized people. They have now resolved a problem. When you have a problem, you need what? A solution, right? So resolve, right? They solve a problem, right? So have firmly and solemnly resolved to live in unity and harmony as one indivisible and indissoluble sovereign nation. They're one people now, right? They're a sovereign nation, sovereignty under God, dedicated to the promotion of inter-African solidarity, world peace, international cooperation, and understanding, and to provide for a constitution for the purpose of promoting the good government and welfare of all persons in our country, on the principles of freedom, equality, and justice, and for the purposes of consolidating the unity of our people, do hereby make, enact, and give to ourselves the following Constitution. See, they ain't begging no colonists for nothing. They enacted their own Constitution. They have their Declaration of Independence. Then they wrote their own Constitution. They started checking boxes of international law, the customs of international law. Right? By a unilateral act, they recognized themselves. They had a reparations of self. They have to repatriate back to the state. It's a state constitution, right? You know, it's like when you get their general provisions, they start to read and start to tell you more about who they are, okay? And they'll tell you, right here in section 2, 1 and 2.
Section 2, number 1. Nigeria is one indivisible and indissoluble sovereign state to be known by the name of the Federal Republic of Nigeria. Number 2, Nigeria shall be a federation consisting of states and a federal capital territory.
All right, thank you very much. So it's about states, you see? So the Africa's been decolonizing for over 60 years. But the Moors over here in the West keep trying to enforce the colonist constitution. Imagine if Nigerians right now say, enforce the Constitution of France, thinking that that's where they get their rights. But that's what the Moorish Americans are doing. They're saying, enforce the Constitution of the United States of America. Well, that's just like the Nigerians saying, enforce the Constitution of France to get your rights. This is what Moorish Americans have been doing. Yeah. It's ridiculous. Right? Keep it in mind, I used to be a Moorish American, right? I'm guilty of this myself, but I had to get out of fellowship and get into scholarship. This is scholarship. Our people got to wake up and go read the truth about your own status. Your status is stateless. Or at best, you are conquered people on the capitulations to be naturalized Moors under the jurisdiction of a colonist commonly known as the United States of America. And you consented and acquiesced to that status, knowingly or unknowingly. And that's the truth. But the Nigerians know. They ain't colonized no more. Now, are they dealing with neo-colonialism? Yeah, but that's a totally different subject matter. But they ain't technically colonized no more. They're self-governing. But now they got to figure out how to fix the administration to get rid of the bad actors. That's the problem. But what are the Moors doing? We still dependent people on the United States and their 3 branches of government. Instead of us being self-governing Moroccans with our own 3 branches of government. We got to wake up as a people and realize we've been hoodwinked and led astray by our leaders. Okay, moving on. So I want to say congratulations to Nigeria, and we appreciate all the hard work you've put into being to self-governing and decolonizing. We thank you, and we will continue to follow in the footsteps of Africa, to learn from Africa. Okay. Now, keep in mind, we're still going over the Charter, okay? Charter of the United Nations of 1945, we've already read through up to chapter 8. Let's take it to the board. Okay. Right now, what are we going over? The Charter of the United Nations chapters, we already been through chapters 6, 7, and 8, okay? And what is chapter 6 about? It was about the settlement of disputes. How do you settle disputes, right? So now we got to figure out, okay, how do we now get into like mediation, arbitration, adjudication, right? And how do we deal with things, regional arrangements and organizations? Well, how do we deal with regional arrangement? Well, regional arrangement among states, state-on-state disputes. But sometimes you can even bring in an intermediary, such as an international organization, to deal with the dispute, right? Such as the Wazir Regional Council, right? Okay, but continuing. So all this is about what? The responsibility of states for internationally wrongful acts. So if someone breaches your rights, right, if they cause an injury to your state, now you can invoke international law that's already set forth in the year 2001 about how do you get reparations for an injury, right? So it's called responsibility of states for internationally wrongful acts, right? Another drop-down box. So what are we seeking now? It's about what? The obligations of reparations due to an attribution of injury caused by a state and its organs. So what are organs, right? We learned that in class 117. Organs is what? Any of the departments of a state, right? So all their government officials sit in chairs of their offices, their departments, right? Their agencies, right? So you're talking about the organs are the officers themselves, the officials. Talking about the departments. You're talking about counties, the municipalities. All these things that the colonists call their governmental agencies are organs, including the officers, magistrates, prosecutors. All of them work on behalf of the charter states, or they work on behalf of the federal government in some form or fashion, right? Those are all organs, okay? So next, what are we going to talk about a little bit today? Okay, so since we're talking about the responsibility of states, right? The responsibility of states, well, what type of state is the next question? Okay, so there's different types of states. It says a state status can be external, or a state status can be internal, or a state status can be integration regarding self-determination. Right? It's 3 different levels. Okay? Now you notice on Nigeria's constitution, it started talking about some other states. Right? So let's go back to Nigeria as an example. Okay? So you have Nigeria's preamble, okay? So Nigeria will be considered the external state name. That's the sovereign name, Nigeria. But within its international borders, it's already saying that it has other states, right? Right here, section 2, it says, Nigeria is one individual and indisposable sovereign state to be known by the name of the Federal Republic of Nigeria. That's the external state. Then it says, section 2, Nigeria shall be a federation consisting of states, plural, and a federal capital territory. You see that? So therefore, Nigeria has internal states within it. Okay? But what if Nigeria also had an Indian reservation within Nigeria? Well, that Indian reservation would be considered what? An internal state, because it has its own autonomy. You see? Let's use another example. The United States of America. The United States of America, that's the name on their Constitution, that's the name on the treaties, United States of America, but within it, it has 50 plus union states. Those are internal states based upon how the United States of America recognizes its own internal states. Now, does that mean that Moors have to recognize the Union states as being states? No, because recognition is a political consideration. But the reality is we all know that the United States of America is in a shallow grave and its agent, its representative, is the United States Federal Corporation. And that federal corporation now has set forth the 50 charter union states. They're not states, they're actually constituents of the United States Federal Corporation. Therefore, they're really just LLCs, unincorporated territories of a corporation. Because a corporation cannot create states. Only states can create a corporation. And then that corporation can create what? Other charters and other LLCs, you see? So in the 1871 Act of Congress, the United States was created as what? A municipal corporation. And then it set forth to create what? 50 different LLCs underneath it, commonly known as the state of Texas. There's a charter of a federal corporation, you see? But the United States, in their 50 territories, they recognize each other as what? States. But they're entitled to their self-determination. But Moroccans don't have to recognize their territories as organic states. We don't have to do that. We have a choice in the matter. It's called a political choice, right? So let's talk about that a little bit today, okay? So, all right. Okay, so we already talked about the fact international organizations, okay, international organizations such as these 7 organic states, right, are acting right now at this current date of 2023. These are all external states that have come together under a convention to work through an international intergovernmental organization, okay, that represents the Moorish Empire, okay? But moving on, that's the WRC convention. As we know in class 117, we're reading over the responsibility of states for internationally wrongful acts, right? So we had already got down to Article 4, right? We read that several times. Okay, as a refresher, we'll read it one more time. But before we go on to Article 5, we have to go over some other information regarding states, okay?
Chapter 2, Attribution of Conduct to a State. Article 4, Conduct of Organs of a State. 1. The conduct of any state organ shall be considered an act of that state under international law, whether the organ exercises legislative, executive, judicial, or any other functions, whatever position it holds in the organization of the state, and whatever its character as an organ of the central government or of a territorial unit of the state. 2. An organ includes any person or entity which has that status in accordance with the internal law of the state.
All right, so in this example, the United States of America will be the state, right? That's the external state when you're looking at the colonist status, right? So who is their external state of the Americans? That's the United States of America, right? And underneath the umbrella of the United States of America, you got what? You got the United States, okay, as an intergovernmental organization. Underneath the United States, what do they have next? There's several union charter states, right? So it's 3 levels to it. Okay, 3 levels to it. So this is what we're starting to learn. Who has jurisdiction? So we're talking jurisdiction. When you're talking state, you're talking jurisdiction. So United States of America, right? United States of America as a jurisdiction has original jurisdiction over who? United States. United States Intergovernmental Organization has jurisdiction over who? The several union states. The several union states have jurisdiction over who? All their counties, their municipalities. You see? So it's different levels to it in their jurisdiction. All right? Okay, let's talk our jurisdiction as Moors. Who has original jurisdiction in our jurisdiction? That would be the Empire of Morocco. It's up here. That's the first original jurisdiction. It's the Empire. It's the first jurisdiction. Underneath that is what? All the several Moroccan states, the provincial modern Moroccan states come underneath that because our provincial Moroccan states recognize the empire. Okay? And then we've got what? the WRC, the Wazir Regional Council, is an intergovernmental organization because that intergovernmental organization doesn't have a constitution. It's just an intergovernmental organization. It's not claiming to be a constitutional state. It's a legitimate intergovernmental organization, okay? Based upon jurisdiction, those 4 jurisdictions, okay? Now, we're going to learn a little bit more about this word called state and jurisdiction. It's very important because as we start to understand how do we bring reparations against a state, well, we should learn, first of all, who are we actually bringing the reparations against, because in international law, you have the obligation to know who's the external state or who's the state party that's responsible for all the other functions, all the organs underneath it. All right? So we have to talk about what's called, well, what I got on the board. Here we go. We got to talk about state status, okay? State status can be external. State status can be internal. And state status can be integration regarding self-determination. Okay? We're going to learn a little bit about that today because we have to know who do we bring the suit towards. If the state of Alabama does something to injure you, do you bring the suit directly against the state of Alabama? Well, the answer is no. Who do you bring against? You bring against their external state, which is the United States of America. State of Alabama is 3rd on the list. You bring the suit against the United States of America, United States, and the state of Alabama, all 3 of them. But you must bring the suit against the United States of America, primarily, because the state of Alabama comes under the United States of America. So the United States of America is ultimately responsible for the actions, the conduct, the attributions of Alabama. You see? It's just like your children. You as parents get in trouble when your children do something out in the street. You're the external parent. Your child, when he's away from home, he becomes like an extension of you. He's the internal child, but you're the external parent. You're obligated for everything your child does. Even if you didn't have nothing to do with it, you get blamed for it. You see? So we're talking parent state versus everything underneath it, okay? All right. Let's get some basic understandings here, okay? About what internal and external and external state. This is important. This is the conversation we have is a subject of international law. We're talking about the subject of international law. Okay? This is very important for Moors to understand. Who do we bring the suit towards? Who are we as Moors? Do we have an internal state or external state? We're going to learn about that, okay? Brother Dre?
Internal and external state can refer to different concepts depending on the context. Here are some examples. In general, internal refers to something that is bounded by the limits of whatever is contained within, while external refers to something that is outside those limits. In sociology, internal sovereignty refers to absolute authority within one's own territory, while external sovereignty refers to the ability of the state to independently and autonomously in the face of external forces.
All right, so internal and external state, we're talking statehood, can refer to different concepts depending on the context. Here are some examples. In general, internal refers to something that is bounded by the limits, whatever is contained within, while external refers to something that is outside those limits. In sociology, internal sovereignty refers to the absolute authority within one's own territory, while external sovereignty refers to the ability of the state to independently and autonomously in the face of external forces, okay? So, an external state would be the United States of America. The internal state would be an Indian reservation. I'm trying to give you an example. If someone was to attack the United States of America would be responsible, but yet the Indian reservations wouldn't be responsible because they're internal. You see, I'm talking jurisdiction right now. But when it comes to Moors during what's called decolonization, right? Self-determination down here. Self-determination of Moors, as we're going through our varying stage of advancement of decolonization, we're seeking self-determination, right? So what status are we going to have? Is our status going to be external, meaning that we're the sovereign, the true sovereign, the original jurisdiction? Or are we going to be internal, right? Internal self-determination, like an Indian reservation? Or are we looking at integration? Integration, because Sidi Muhammad allowed the 13 colonies to integrate in the Empire of Morocco. What does that mean? They've been able to roam, right? So the 13 colonies have been living amongst the Moors. The Indian reservations were set aside reservations. Okay? But the Moors have always lived amongst the 13 colonies because we're the indigenous people of the land. The 13 colonies were given asylum and refuge to stay in the Empire of Morocco. So they're our neighbor. They live right next door to us. Whereas the Indian reservation was a set aside in the area commonly known as Oklahoma, etc. So you have to understand these are three levels. You got internal, external, and integration. We'll start learning more about this as we go. This isn't a one-time class, okay? So what we're learning here is internal and external state. Okay, let's scroll down. Okay, Brother Dre.
What is the difference between external state and internal state? Internal state is the counterpart of external state. External state is state visible from outside the object.
All right, thank you very much. So what does that mean? External state is the state visible from outside the object. What does that mean? That means the world recognizes the external state. The world does not recognize the internal states. The world does not recognize state Alabama. The world does not recognize any Indian reservations. The world recognizes the United States of America. The world recognizes the Empire of Morocco because the Europeans recognize the Empire of Morocco through treaties. Therefore, any internal states technically are not a subject of international law because a subject of international law will be the external state. And that external state is responsible for everything underneath it. So therefore, you bring the suit towards the external state that everybody sees as an object. How do you see it? Because it's on paper of treaties and constitutions, and those constitutions have been deposited and registered with the United Nations in accordance to Article 102. You see? So state Alabama on planet Earth is not recognized as a state. And neither is any Indian reservation. They're all internal. The world focuses on external. You understand? Okay, listen. We got to go over this. Why are we going over this? Okay. Because we're talking about the responsibility of states for internationally wrongful acts. We can't talk about the conduct of a state and its organs until we first understand what's the external state who's actually we need to bring the suit against. And then we need to understand who the heck we are. The parties must be known. Who are we? Are we the external state? Are we an internal state? You see? These questions must be asked. They must be qualified and solidified through what's commonly known as the legal argument, the legal defense. Right? So we can't keep reading this until we understand the parties. Who's external, who's internal, or what is integration? That way, now we know how to bring the suit. I'm being redundant. Okay? Okay. So, here's a dissertation, right? A thesis and dissertation. Theses and dissertation. And I found this online. I thought it was good information. I've learned a lot from it, from someone else's opinion, right? So whose document is this? Okay, let's give them credit where credit is due. Okay, no.
This is from the Golden State University School of Law, GTU Law Digital Commons, spring of 2016, on the development of the law of self-determination from external to internal aspects. Vadim Anatolievich Godorza, Golden State University School of Law.
All right, so this is a dissertation on the development of the law of self-determination from external to internal aspects. So this law school is taking a look at the difference between external statehood and internal statehood. This took place in 2016. All right, so the colonists, i.e. the Americans, they are always studying. They want to know the advantages and disadvantages of states. As soon as you see the word right here, self-determination, they already know that's the word used in what? Decolonization. They know that's a word used even in Europe when the European states are now declaring what? Their own self-determination to be a European state such as Ukraine. Right? So self-determination isn't always exclusive to decolonization. However, the word self-determination is more often than not is a higher probability that when the word self-determination comes up, it's about the rights of indigenous people. That must be understood. It's a higher probability versus the exception to the rule. Because the Europeans already have their states, don't they? They're already more or less solidified. So who do you think they're talking about in the year 2016 if in fact the European states are already basically in place? So why do they keep studying about self-determination? It's because they're studying what these indigenous people's rights are and are not. They want to know. And this is what more should have been studied. We should have been trying to determine what is our right to self-determination. Right? We read over Nigeria's constitution. They said we did this for ourselves. You see? It's called unilateral act, political act, okay? So what we're going to do is, we're only going to read a couple pages of this, okay? Only a couple pages. Okay, we're going to start with the abstract. Keep in mind, it's a dissertation, a thesis, dissertation. So let's read over somebody's opinion from a law school that's talking about what? International law. This is the subject of international law. More specifically, the subject about what? Self-determination that's recognized in international law. Now they want to break it down into subparts. There's external statehood, internal statehood, and then there's this thing called integration. Right? We'll talk about that. Okay, no.
The crisis within international law of self-determination cannot be ignored. This dissertation analysis and discusses the reasons for the crisis, which are the lack of analysis of the correlation of legal doctrines with doctrines of social science, a general absence of analysis of the changes occurring within contemporary international law due to the changes of doctrines of social science, particularly on the topics of the subjects of international law and on the law of self-determination and recognition. A lack of analysis of the new laws within a context of rapid social development, and finally, the absence of a development of a methodology for the purpose of research and analysis for the current issues within international law, especially since the 19th century. Using the European family of nations as case study, This paper will analyze the history and development of nation states and will propose a historical and comparative law method as a method both for general comparative research and further research on the development of the law of self-determination as interrelated doctrine with the doctrine of constitutionalism. This dissertation will introduce the theory of constitutionalism within the framework of analysis and will use it as a mechanism for the furtherance of the law of self-determination, recognizing the principle of peaceful coexistence, and finally, for the development of international law generally.
Okay, so you you have to dodge the hijack, right? You can't. In my opinion, you don't look at this from. They're saying it's a study of what they're studying Europeans, right? You can't turn around and say, well, they might be studying European, but what they're really studying is, right? They're saying, oh, we're studying European states about self-determination. Nah, it's under the guise of saying it's about European states. What they're really studying is about these Moors. What rights do Moors have? Because they know Moors have what? Treaties. Right? So they're trying to figure out if these Moors start to enforce their treaty rights, not privileges, rights, treaty rights. And on top of that, they started utilizing international law in addition to their treaties. Then what type of states are these Moors going to have? Are they going to have external states or internal states? This is what they're studying. The Europeans are studying this. Because they know that there's Moors even where? In Queen Europa's land. You see? So they're concerned about Moors waking up. The Europeans have to contemplate seriously, just like Hoffman Phillips said in the expatriation doctrine of 1906, where they were talking about these Moors, said when these Moors wake up and they come into the consciousness of the Treaty of Madrid of 1880, Article 15, paragraph 1, that all the Europeans are going to have to stand up and recognize these Moors got treaty rights, not privileges, treaty rights. But now they say, okay, let's break it down in 2 parts, maybe 3. Well, what's the first part the Europeans are looking at? They're looking at, okay, do these Moors have external state rights to be the sovereign state? Or do these Moors have internal state rights where they have to act like an Indian reservation? Or are we going to get into integration? You see? Based upon self-determination, because they know self-determination is a subject of international law. What does that mean? International law has what's called subject matter jurisdiction. When you're dealing with the act of decolonization or self-determination, international law gets subject matter jurisdiction, meaning the courts and the laws of international law reign supreme. Isn't it what the United States Constitution, Article 6, Supremacy Clause says? Treaty supreme law of the land. It's even written in their Constitution, treaty supreme law of the land. So therefore, Europeans are studying our treaties to see what rights we have under statehood. Now, what's really got their biggest attention? Okay. This case of 1952, Brother Drake, can you read the title from top?
International Court of Justice. Reports of judgments, advisory opinions, and orders. Case concerning rights of nationals of the United States of America in Morocco. France versus the United States of America. Judgment of August 27, 1952.
So the United States knows the Illuminati secret came out in 1952. What's the Illuminati secret? That the United States of America is where?
In Morocco.
In Morocco. What part of Morocco? Empire of Morocco, right? So they've been very, very, very concerned since this date because the world found out. In case they didn't know, now the world found out through a world court that there's case law from a world court that expose the fact that the United States of America is in Morocco and that Morocco is not in America. Right? What else? Why else are they studying external and internal statehood? Well, it's because of this treaty. Treaty is supreme law of the land. This is the very treaty the ICJ was looking at in the case of France versus United States of America. The International Court of Justice judges were going back to look at treaties. Therefore, the Europeans are going back to study these treaties as well, to see what rights these Moors actually had. Right? So in looking at this, now you come down to the preamble. The preamble, they know the preamble right off the top hurts them, right? Because now the parties must be known, right? So in the preamble, who are some of the parties? It says, well, the President of the United States of America. That's one of the parties to the treaty. Who else was it there? Okay, the President of the French Republic. The French were there. Okay, who else was there? His Majesty the King of the United Kingdom of Great Britain and Ireland and of the British dominions beyond the sea. So look who's there. United States is there. France is there. And who else is there? Great Britain. You see how they bundled all three of them? And all three of them sit where? On the Security Council of the Charter of the United Nations. They're already perfectly aware about the rights of Moors, of self-determination, of external self-determination of statehood. Well, why do I say that? Okay, now you come down, okay, now here's another party. Who else was there? His Majesty the Sultan of Morocco, right? So Sultan of Morocco is on one side of the table and everybody else is on the other side. Sultan of Morocco is on one side of the table all by himself. You got the 12 signatory powers on the other side of the table. That's how that worked out. The parties must be known, okay? But then you get right into the preamble, right? The preamble tells you the answer to the test. It tells you the rights of the Moors, okay? All right, so let's start with inspired, Nova.
Inspired by the interest attaching itself to the reign of order, peace, and prosperity in Morocco, and recognizing that the attainment thereof can only be effected by means of the introduction of reforms based upon the triple principle of the sovereignty and independence of His Majesty the Sultan, the integrity of his domains.
Pause. All right. Let's just stop right there. Okay. So right in the preamble, it talks about recognizing the triple principle of the sovereignty and independence. You see that? Sovereignty and independence. Did it say sovereignty and dependence? It didn't say nothing about dependency, did it? It said independence, right? So the Moors have a right to sovereignty and independence, and not just sovereignty and dependence, you see? So what does that mean? Already off the top, in a treaty, it says what? Independence automatically gives you what? External sovereignty. If it would have said sovereignty and dependency, that would automatically mean internal, you see? But always keep in mind that the United States of America is located where? In Morocco, so that automatically more or less puts us in the status of what? Integration, doesn't it? Because they integrated along with us. We're commingled two nations. But the question is, who has jurisdiction? When I say jurisdiction, I'm talking about who has original jurisdiction of being the external state and who has subject matter jurisdiction and now enforcing their courts and laws. You see? So as we start to get into the responsibility of states for internationally wrongful acts of the year 2001 as a treaty, we got to know who do we bring these disputes against? And more importantly, who gets to enforce their laws in courts in that case? This is important to understand. So let's read it again. This treaty is all about recognizing the triple principle of sovereignty and independence of what? The integrity of domains. Domains is what? The realms, right? The territory, the land, the state, right? So it's already set forth and recognized. What was recognized? The empire. That needed to be broke down into states. Well, it was already broke down into states. Because the Europeans themselves had what? States. They're all residing where? In the Empire of Morocco as states. But what type of states? You can recognize them as external states. However, what's the original jurisdiction? It's the Empire of Morocco. You see? The Sultan has allowed the Europeans to integrate into the Empire of Morocco. For them to have their own sovereignty and autonomous ways of governing themselves. The French govern French. The British govern the British. But the question is, who has original jurisdiction in the matter of a dispute? And it always goes back to the Empire of Morocco. Same thing with the United States of America. The United States of America is located where? Okay. United States of America is in Morocco. So therefore Morocco has what? The original jurisdiction. It has subject matter jurisdiction. Listen. Let's go back to the letter. Okay. Now we're only going to read about 3 or 4 pages of this, okay? Because we don't want to lose our point. But you got to understand some basic concepts of what the Europeans are studying. Right? Just follow them and they'll expose everything for the Moors. Just follow what they're studying. Because they're very curious. Guess who else needs to be just as curious? Moors.
Exactly.
Stop studying municipal law. You need to be studying international law. Okay. Chapter 1. Good brother Dre.
Chapter 1. Development of the law of self-determination in the 20th century. This paper is to analyze development and changes of concepts and different approaches to problem of the self-determination of peoples and nations in contemporary international law due in the development and changes of the social science. It can be concluded that the changes occur due to the changes of doctrines of development of the society from the nation states to the development of the doctrine of constitutionalism.
Pause. See right here, they're already letting you know something. You got to catch this stuff immediately. They're already studying, okay, they're studying, okay, from the nation states to the development of the doctrine of constitutionalism. So from nation states to constitutionalism, meaning the Empire of Morocco didn't have a constitution. But now the Moors are establishing what? Constitutions. It's constitutionalism. They're talking about the doctrine, the theory that these Moors are getting into what? Constitutions and statehood, because that's the proper mechanism. That's the proper application of getting into statehood. You needed a constitution, Moors. You just can't say, well, the empire exists, so we should just be able to do what we want to do. No. We're in what you call contemporary international law. You got to pay attention to what they're saying from jump. Catch it more. So therefore, they say this theory of just from nation states, right? You see they said nation states, because this is what Moorish Americans think we have right now. Moors think we kind of sort of have a nation state already. They run around proclaiming themselves and purporting that they are already government officials. And they're self-appointed government officials because they think they got a government already. That's called your nation state. That's a theory. That's an abstract in your head. That's a state of mind, but that's not a state based in a constitution. The Europeans are saying you need a constitution. You don't need no nation state. That's a theory, but this is what? Absolute, substantive, because it's in writing. It identifies the parties like Nigeria did. It identifies the landmass, the latitude, longitude. You got to understand what's happening. And you got the ability now to what? Get into relations with other states.
Right.
Because the Constitution allows you to get into relations with other states. You can't get access to international law without going through the portal of a constitution. Because only states can be parties to treaties, you see? See how the Europeans schooling us already, but if you don't catch it, it'll slip right past you. Okay, let's read it again. Let's read it again.
This paper is to analyze development and changes of concepts and different approaches to problem of the self-determination of peoples and nations in contemporary international law due to the development and changes of the social science. It can be concluded that the changes occurred due to the changes of doctrines of development of the society from the nation states to the development of the doctrine of constitutionalism.
Right? So it's about a society from the nation state. That was a theory. Now, contemporary international law says from the nation state theory to contemporary law of the development of the doctrine of constitutionalism. Okay, let's pause right there. Listen. This is Tajri Bey I got on here. Remember, I played this already, I think, class 115 or 116, right? I was talking about, listen to what Todd said, we need a nation state. Right? This is what he's telling the blackamoors, these black sisters that trying to figure out, are they Moors? They're trying to figure out who they are. How do they get reparations? They're trying to fix the problem. Todd is trying to tell them the solution. But even Todd's concepts are still old school. Right? Listen. Just a moment.
But you must identify the pedigrees of the nation states. Now, what next?
So Todd said we need the nation states. Well, guess what, Todd? That's an old school mentality. Contemporary international law is about constitutionalism. Todd don't teach the people that the Moors need their own constitution so they can have their own self-determination to get into statehood. This is what's wrong with the old paradigm. The old paradigm think we can just do what we want to do under the word called Moor. It don't work like that.
Nope.
You must have the consciousness of international law. The world has moved on past these old paradigm Moors. We have to follow the instructions, the due process of international law. Okay, listen.
Must identify the pedigrees of the nation states. Now, what nationalities are the injured parties and what nationalities are the aggressors or the violators of international law? Name them.
So he's asking these sisters to name the state. Well, Tajri Bey can't even name the state. So he's asking them to name the state. We have to understand, this old paradigm got to go away, got to put it to the back. Blackamoors don't know the answer to the test, and clearly Taj don't know the answer to the test, and the halfway answer he knows is nation state, and right now we're studying the Europeans, and the Europeans are saying, you got to get away from this theory of nation states. And these Moors got to have constitutions if they want their rights.
Absolutely.
Because the Constitution identifies the nationality. We looked at Nigeria's constitution as Nigerians. Mm-hmm. And they had a government. They have a recognized latitude, longitude of their state. Mm-hmm. And they got government. You got to understand what's happening here. We wasted a lot of time as Moors. Listen. Let's continue with the read.
The starting point of the analysis of self-determination is that the modern law of nations is a product of Christian civilization and social science generally. That leads to the next logical step, that international law is based on the assumption that there exists an international community embracing all independent states and constituting a legally organized society.
Paul, so what creates an independent state? Constitution. You see that? You got to catch how they're talking. What creates an independent state? Constitutions creates what? A legal status, a legal defense, a legal argument. You need constitutions. You got to hear what they're saying. You want to be independence Moors? You need a state. Okay? Okay, Brother Drake.
From this assumption, there necessarily follows the acknowledgement of a body of rules of a fundamental character universally binding upon the members of that society.
Pause. What's that called? Internal domain. That's your three branches of government. Governing the people. That's an organized jural society because the government makes sure that the people live by laws. The state creates the laws, and the laws are binding on its nationals, you see? And it's binding on anyone within their territory, no matter what the population is. Your laws of your state, your independent state, are binding on everybody within your jurisdiction. You got to hear what they're saying.
It means that in order to analyze development of the theory of self-determination, it will be necessary to describe in short development of the system of states in Europe, to introduce development of the theory of international law, to evaluate relations and influence of social sciences such as political science, philosophy, history, foreign policy, and diplomacy on the development of international law concepts, the development of the system of states approaches, and the development of the theory of self-determination and how it correlates to the development of social science is at issue of this thesis.
Pause. Listen to what he's saying. The development of the system of states. Moors are trying to develop states. You see? Mm-hmm. See, the Europeans talking about these Moors under self-determination need to develop states. And the only way for them to develop a state, they need what? A constitution. You got to catch what they're saying. From the top, the development of the system of states. The development of the system of states. The development of the system of states approaches and the development of a theory of self-determination of a state and how it correlations to the development of the social science at issue of this thesis. You see? They're telling the Moors the answer to the test. This has been out since 2016. Continue.
The theory of the self-determination is a universal theory, but different schools of international law approach to it in different ways. Despite the fact that the problem of international law as universal legal system was never resolved, and in the beginning of the 19th century, various conceptions of the law of nations insisted and studied the difference between the so-called Anglo-American and Continental School of International Law contemporary. International law theorists and scholars agreed with the view that international law is a universal system.
All right, so now international law is universal. So all Moors have to study universal law and stop studying domestic municipal law of the state of Virginia, the state of Massachusetts, and the Supreme Court of the United States. That's domestic municipal law. Moors have been studying what? Universal international law. Contemporary international law regarding what? Self-determination of Moors who needed a constitution in order to establish a state. Brother Drake?
In this dissertation, it will be analyzed that the development of the theory moved from the aspects of external self-determination of peoples and nations forming states on the first stages of formation of international community to the more complicated systems and aspects of internal self-determination due to the development of political systems, philosophy, and social sciences generally, how the doctrine of constitutionalism replaced the theory of the nation states, and results is that the self-determination started to develop mainly in internal ways.
All right, so this one paragraph tells you just about everything you need to know about putting an old paradigm to the back and having a new understanding, new paradigm, understanding international law, contemporary international law, and the theory of universal international law. Listen, in this dissertation, it will be analyzed that the development of theory moved from the aspects of external self-determination of the peoples and nations forming states. On the first stages of formation of international community to the more complicated systems and aspects of internal self-determination due to the development of political system, philosophy, and social sciences generally. How the doctrine of constitutionalism replaced the theory of the nation states. You see that? This is what Taj V. got to understand. This is what the Grand Sheiks have to understand. This is what the ministers of the mosque must understand for the black man. The black man needed a constitution. But ain't no such thing as black people as a nationality, is it?
No.
They're Moroccans, not black men. All right? So it's all about the result, right? The result is that the self-determination started to develop mainly in an internal way. So now you got to see what the Europeans are doing. They're studying external self-determination and internal self-determination because they know chances are they're going to end up in a status of what? Internal self-determination.
Mm-hmm.
Or they're going to end in a status of what? Integration self-determination. But they already know they can't hold on to external self-determination. They know this already, so they're studying it. What are the legal rights of Moors? What are the legal rights of colonists or conquerors, right? What's the rights of Europeans? What's the rights of Moors? That's the question. Now they break it down. External self-determination, internal self-determination, and obviously there's integration as a status, right? Because we've always been living together as Moors and Europeans. That's never going to change. But what has changed now is called jurisdiction. We'll get into that. So I need Tajri Bey and all the Grand Sheiks and all the black people to understand this. We need constitutionalism. Will replace the theory of nation states. You got the Nation of Islam. No, Nation of Islam. We need constitutionalism based on the theories of international law and not domestic municipal law. We got to understand this. This is too easy. This has been out since 2016. Let's continue.
At the same time, the differences in the notions, methods, and institutes of the international law of self-determination still must become subject of thorough research. This fundamental question that must be answered: does internal aspect of the self-determination replace the external way for the self-determination of peoples?
You see what he's asking? Mm-hmm. Are the European states going to become dependent states? That's the question. Let's read it again from the top. At the same time, the differences in the notions, methods, and institutes of the international law of self-determination. So he's saying this self-determination is bound and protected by international law. So they're looking at the legal defense and the legal arguments that Moors will have. Right? Of self-determination still must become subject of thorough research. This fundamental question that must be answered: does internal aspects of self-determination replace the external way for the self-determination of people? You see that word replace? See that word replace? Yeah, catch how they're talking. They're talking to each other. They're saying, we got to beware because these Moors are waking up. Because of the United Nations Charter itself, Article 73 gave Moors a right to their self-determination. They know that several resolutions from the United Nations came out regarding United Nations Resolution of 1514 of the year 1960. Resolution 2625 of the year 1970, etc. gave Moors rights to have their own self-determination. But what type of self-determination is the question? Is it external self-determination or internal self-determination? Or are we looking at integration? Europeans been asking this question. They're trying to get ahead of it so they can prepare themselves. This is the same thing that Hoffman Phillips said in 1906 in the expatriation document, page 459 and 460. Hoffman Phillips said, when these Moors wake up and they repatriate back to the Empire State of Morocco, then the Europeans will have to contemplate seriously of what they're going to do. So they're contemplating, aren't they? Because they're about to be what? Replaced. Trading places. Eddie Murphy. Listen. All right.
Looking for opportunity to preserve its culture and self-identification requires research of the views on nature of international community and the theory of the subjects of international law, from the prospect of different branches of social science and international law. The differences in the approach to the definition of the subjects of international law will allow to define the dominion of international law from the point of view of the major regional doctrines and will make possible to make the conclusion. Subjects of international law can be characterized by their sovereignty. It means that study and comparison of concepts of sovereignty can be used for creation of the new system for development of the law of self-determination in the science of international law.
Pause. Subjects of international law can be characterized by their sovereignty. What's the subject of international law? What are they talking about here? Subjects of international law can be characterized by their sovereignty. They're talking about the Moorish treaties. The Moorish treaties already set forth the sovereignty, because treaties are a subject of international law. All treaties are a subject of international law. So Moorish treaties are a subject of international law. Therefore, treaties now take over what's called subject matter jurisdictions, because the subject matter is the treaty. Therefore, whoever has the treaty and that person's superior in the treaty, now they get to maintain the external subject matter jurisdiction of both their laws and their courts. This is why they're studying it. Continue.
Another related issue to a theory of self-determination of peoples and nations in the theory of international law and in the theory of general social science is a theory of recognition. The practice of recognition of states as a result of self-determination sometimes moves in different directions. As an example, recognition by the Russian government and denial of recognition by the Western governments, supported by different arguments with regards to the rights of self-determination of peoples and nations, exposes different approach for analysis of the nature of sovereignty and appealing to declaratory or constitutive theories of recognition.
All right, so what's happening? Now they're talking about what? Recognition, right? Mm-hmm. They understand the practice of recognition of states. Now the Europeans saying, which one of you Europeans gonna recognize the Moors when they have a state? And they say, Russia probably gonna be the first one to recognize the Moors' statehood. You see how they're picking on Russia? Trust me, this is very strategic what they're saying. So soon as Russia is one so-called state, because Russia sits where?
At the Security
At the Permanent
Council.
Security
Permanent Security Council. See, so they got a lot of power. Russia got a lot of power. All the 5 permanent members of the Security Council, they call themselves the P5. Mm-hmm. If any one of those 5 recognize your state, just one of them, you've been recognized.
Right.
So they say Russia probably gonna be the one recognizing all the Moor states.
So that they could kick out the United States and put the Moors.
Yeah, Russia knows what's up. Now that doesn't mean I'm for Russia or against Russia. We're talking about this thesis, right? Dissertation, that all it takes is one state, a member state at that of the United Nations. There's 193 member states. Mm-hmm. And all it takes is one member of the United Nations to recognize a Moorish state. So then they just took the time to throw Russia's name in it, right? Mm-hmm. You gotta see what's happening. Mm-hmm. You see? Especially since Russia sits on the P5, right? But it's talking about recognition. So they're saying, we can't really stop these Moors, because not only are Moors gonna recognize each other's state, okay, let's go back. Not only the Moors going to recognize, like all 7 of these states have already sent official expressed certified letters to each one of themselves. They sent, like AMPAC sent a recognition letter over to Meru State Republic. As a Moroccan state, Meru State Republic turned around and sent a recognition letter recognizing AMPAC, you see?
Mm-hmm.
So Moroccan states are already recognizing each other.
Yep.
Right? Because we're controlling our own tempo. We ain't waiting on nobody. Our treaties gave us the right just to govern, period. Just jump in with 2 feet and get to work, period. Right? However, when you're talking recognition of states, they said if any one of the 193 member states recognize a Moorish state, automatically they get recognized on a much higher level.
Mm-hmm.
You see, just one of the 193, Cuba, could recognize a Moorish state. You see? Because Cuba is a what? Member state of the United Nations.
Yep.
You see? So they're saying we can't stop these Moors even with recognition, because the Europeans will say, well, let's not recognize none of these Moor states. They say, well, that ain't gonna work. The Russians gonna recognize them. Cuba could recognize them. Venezuela could recognize these Moors. You see? So they're looking at their options. They're looking at the legal argument. What's their legal defense?
They have none.
There you go. They gotta contemplate seriously. Okay. Brother.
It is not clear if these differences allow us to make conclusions with regards to universality or non-universality of international law of self-determination, but facts and arguments used in this analysis allows to talk about our differences that can result in reassessment of the future trends and development of the law of self-determination. The development of the principle of self-determination was one of the most prominent and significant doctrines in the theory of international law in the 20th century. Today, it becomes one of the cornerstones in international politics and foreign relations. The key to understanding the Western theories are the underlying theories of social science and international law that were developed in the 18th and 19th centuries. The roots of these doctrines must be discovered in analysis of development of legal traditions and philosophy. The Western doctrines and perceptions of international law originally existed since the Roman and Byzantine Empire and were based on different notions that will be demonstrated in this analysis. After that period of time, development of these doctrines were influenced by transfer of international law studies to East from Western Europe in the later times that evolved further and are still defining attitude of international law scholars toward the processes of self-determination and recognition of newly organized states after the World War I. It can be said that development of the law of self-determination resulted in the development of unique conceptions of theory of international law, and this historically unique system contributed to the development of global international law all the way through the 19th and 20th centuries.
All right, so we won't read any more. This is actually 123 pages, I believe. Just a moment. Yes, 227 pages. So we we're gonna stop right there, right? I just want to give the Moors a brief, right? I'll make sure we'll try to put this link somewhere. If Moors want to go back and read, I think it's a good read. My recommendation to the Moors: start with the contents. Okay, start with the let me just show you real quick why I say that. Start with the contents. Okay, from the beginning, so you can choose what you want to read. Okay, let me just read it. Let me show you why I say start with the contents page. Okay, I'm just trying to school the Moors a little bit. We got to learn about international law, Moors. Okay, we're gonna read just a little bit of the contents. Okay, let's start right here.
Deniers of self-determination as a legal principle, the right to self-determination, external and internal aspects, the concepts of external self-determination in the theory of international law, principles of self-determination, content of the principle of self-determination, claimants for a right for self-determination according to contemporary international law theory, nation in the theory of international law, peoples, minorities, sources of the law of self-determination, the Helsinki Final Act, the character of the concept for self-determination in the Final Act, the 1976 Algiers Declaration, development of doctrine of self-determination as a form of decolonization, self-determination and related problem recognition of states, contemporary law of the recognition of new states, independence, criteria for statehood, practice of recognition, law of self-determination and recognition as a basis for the development of the law of peaceful coexistence.
Peaceful coexistence, right? Peaceful coexistence. What is that? Integration. You see? So they're breaking this down to contents, right? The more should start with the contents page and see what it is where you would like to study, right? It's a fairly lengthy contents page, okay? So a lot of good information. Okay? So I'll make sure somehow, some way we get this link out to all the more so you can go back and study it regarding this author for this particular thesis, okay? All right. So with that being said, keep in mind, let's keep it germane, right? What is this all about? We're trying to understand, okay, we're going over the responsibility of states for internationally wrongful acts, right? Which is a treaty, right? So if somebody's state does something to your state, injure your state, right? You can bring suit against them. But you have to know, are they the external state or they're the internal state? Or is it integration state? You got to understand these statuses, right? Who has jurisdiction? Who has subject matter jurisdiction, right? Okay, slight change of pace. You see what I have up here? You got, as our people already know, we were colonized people, right? And now our people are looking for our identity, right? We have an identity crisis on our hand amongst our people, our community, as a collective of people. And some of our people have decided to go back and say, you know what? We as black people are actually Indians, right? And that doesn't mean the word Indian does not exist, okay? Because the United States of America and the United States recognizes the name Indian in their Constitution, Article 1, Section 2 and 8, I do believe. It's Article 1, Section 2 and 8. So we got our people now putting feathers in their hair, trying to become Indians again. Well, I got no problem with that. Why? Because Indian reservations and the word Indian is recognized in the United States of America's internal laws. And the Indians do actually have treaties, right? So one of the first treaties that the 13 colonies signed, one of the first, was with the Lenape Moors, right? They call them the Delaware Moors or Lenape, right? Now the Moors turn around and add the word Moor to it, but it's just simply Lenape or Delaware, okay? It's standalone words, Lenape or Delaware, okay? And that was in September 1778, okay? So in 1778, the 13 colonies started signing treaties with quote-unquote Indians. All right? So now black people are now going back saying, oh, we Indians. And guess what? I got no problem with that. However, anyone who's called themselves Indians now has to study what? International law. Because you're trying to invoke a treaty. You're trying to invoke a legal personality to call yourself Indian. You're trying to claim yourself as being a part of a tribe or a reservation. Now, here's what you must understand when it comes to quote-unquote Indian. There's three ways that Indians are recognized. So the first one is Indians are recognized by what? A legislative act of the United States to recognize a reservation. That's one status. Another status is it can be an executive order by the President of the United States to recognize a reservation or tribe. And the third way is by the Supreme Court or a court. United States District Court can recognize someone's status of being of a reservation or tribe. So you got, it can be a legislative act, it can be an executive order from the president, or it can come from a court. Those are three ways that Indians are recognized. But they got to get permission from who to be recognized? The United States. Or they don't exist. You got to catch what I just said. The Indians don't have a right to turn around and recognize the United States. Only the United States reserve that right to themselves to recognize anyone calling themselves Indians. Listen. Jurisdiction. Let's look up the definition of jurisdiction, because the Indians are black people who are actually not black. They have a right to self-determination to call themselves black, but that's not a nationality. Black is not a nationality. Okay? So we got to understand, what is jurisdiction about? Jurisdiction is about who has power, supreme power, based upon their jurisdiction. But first, let's look up the definition of jurisdiction. Nova?
Jurisdiction can be defined as 1, power of a court to adjudicate cases and issue orders, or 2, territory within which a court or government agency can properly exercise its powers. Case law.
Okay, so jurisdiction can be defined as power of a court to adjudicate cases and issue orders, or 2, territory. Jurisdiction is territory within which a court or government agency may properly exercise its power. You see that? Jurisdiction. Okay? So Indians are trying to go back to a jurisdiction of an Indian reservation, etc., because they want to go into a different jurisdiction. Okay? Listen. However, let's look up this United States Code, okay? From the top.
U.S. 18 U.S. Code, section 1151, Indian country defined. Under U.S. Code, except as otherwise provided in sections 1154 and 1156 of this title, the term Indian country, as used in this chapter, means all land within the limits of any Indian reservation under the jurisdiction of the United States government, notwithstanding the issuance of any patent and including rights of way running through the reservation. B, all dependent Indian communities within the borders of the United States, whether within the original or subsequently acquired territory thereof, and whether within or without the limits of a state. And C, all Indian allotments, the Indian titles to which have not been extinguished, including rights of way running through the same.
Okay, so those people who want to be Indians, they want to be a part of an Indian country, reservation, tribe, etc., they should understand what's called jurisdiction. The United States is now invoking jurisdiction over Indians. You see, they even throw the word in there, Indian. And they say it's defined in the what? Okay, what's the reference point? Title 18, USC, subsection 1151. Look that up, right? Title 18, USC 1151. It's going to tell you straight up what rights do Indians have, right? Because they're looking for their autonomy to be on a reservation, but do they have external self-determination? Or are they looking at internal self-determination? You see where we're going with this? Listen. Except as otherwise provided in section 1154 and 1156 of this title, the term Indian country, as used in this chapter, means A, all land within the limits of any Indian reservations under the jurisdiction of the United States government, notwithstanding the issuance of any patent and including rights of way running through the reservation. B, all dependent Indian communities. All dependent Indian communities. All dependent Indian communities within the borders of the United States, whether within the original or subsequently acquired territory thereof, and whether within or without the limits of a state. And C, all Indian allotments, the Indian titles to which have not been extinguished, including rights of way running through the same. So all Indians come under the jurisdiction of the United States. Okay. And section B, it says all dependent Indian communities. So all Indians come under the dependency of the United States. We're talking jurisdiction. So they have what? They have autonomy to self-govern on their reservation, but they still come under the jurisdiction of the United States. You see? This is what's happening. So you got what? You got black people thinking they're going from being black to being Indian, and they think that there's some type of upgrade. No, it ain't.
It's a downgrade.
You go from being simply just subjugated to being subjugated.
Lateral transfer.
It's a lateral transfer, that's right. That's right. We're not being properly taught, are we?
No.
So black people think they run away from the jurisdiction of the United States, and they're not. That's what we got to understand. It's okay if you want to be Indian. I'm okay with that, but you got to study law. Listen. This is a case of McGirt versus Oklahoma of the year 2020. This is what black people need to understand is trying to become Indians. You ain't going nowhere fast. Listen, McGirt was an Indian. Versus what? Oklahoma, state of Oklahoma. Now they're going to talk about jurisdiction. Does the Indian reservation have jurisdiction over Oklahoma? Or does Oklahoma have jurisdiction over the Indian reservation? Well, in this case, spoiler alert, when McGirt took Oklahoma to the Supreme Court, guess what the Supreme Court came back and said? Justice Kavanaugh said what? He said the United States, since they got treaties with Indians, that the Indian reservations have jurisdiction over Oklahoma as a state. You see? Why is that? Because the United States of America signed a treaty with the Indians. It's a treaty. Well, wait. You mean to tell me Indian reservations are states? Yes. Why? Because anytime one state signs an agreement with another group of people and call it a treaty is a subject of international law. And the only people can be a party to a treaty is a state. So now Indian reservations are states, but they don't want to tell the American citizens that truth. And this is why in this case you'll find out why McGirt actually beat Oklahoma, because McGirt was a part of an Indian state. But what type of state? Internal state. You see? So the Indian reservations have a higher status than the chartered union states. Okay. Let's read a little bit about this, and we're going to move on past it. I just want to show this as an example to who? Okay. These Indians. This prima facie Indian needs to know about McGirt versus Oklahoma. You need to understand jurisdiction. Okay? All right. Nova.
McGirt versus Oklahoma. McGirt, in 591 U.S. 2020, was a landmark United States Supreme Court case which ruled that as pertaining to the Major Crimes Act, such as the eastern portion of the state of Oklahoma remains as Native American lands of the prior Indian reservations of the 5 civilized tribes, never disestablished by Congress, a part of the Oklahoma Enabling Act of 1906. As such, prosecution of crimes by Native Americans on these lands fall into the jurisdiction of the tribal courts and federal judiciary under the Major Crimes Act rather than Oklahoma's courts.
Pause. Did you catch it?
Mm-hmm.
So McGirt, which was an Indian, took Oklahoma to court because Oklahoma had prosecuted McGirt. And McGirt said, no, I'm an Indian. You don't have jurisdiction over me, Oklahoma. So McGirt, as an Indian, took Oklahoma to court and went to the Supreme Court. And then the Supreme Court turned around and said, nope, McGirt can only be prosecuted. He can only break the laws of what? His tribe. And only his tribe had jurisdiction. His tribe had jurisdiction with their courts of jurisdiction. And guess who else had ultimate supreme jurisdiction of subject matter jurisdiction? It was the federal judiciary. You see?
Mm-hmm.
Under the what? Major Crimes Act.
Crimes Act.
Rather than Oklahoma's courts.
That's crazy.
You see? It's called jurisdiction. Treaties set forth to tell you who the parties are. The United States of America always knew the Indian reservations had more jurisdiction than the several Union states. You gotta understand what's happening. We're talking treaties, we're talking jurisdiction, talking the power of courts and laws. But you must understand, even in this case, McGirt could be adjudicated by both who? The jurisdiction of the tribal courts and the federal courts. So federal courts have the ultimate subject matter jurisdiction over Indians if the Indians have done something to breach what's called the Major Crimes Act. If it's not a major crime, then the United States don't have jurisdiction to adjudicate Indians. But if Indians violate the Major Crimes Act, right, was a significant major crime, then the feds can come in and have jurisdiction. You gotta understand what's happening. There's different layers to it, okay? So therefore, everybody that wants to be an Indian needs to know that the United States still got jurisdiction over you.
Right.
And the Indian reservation got jurisdiction over you. But wait, time out. You got a lot of people putting these feathers on, and they not even a member of an Indian reservation. So they put on a costume instead of putting on the customary clothing and apparel of a reservation because they're not recognized by the members of the reservation. So now you got to ask these people putting on this Indian clothing, have you been recognized by a reservation? Or have you been recognized by some tribe? Because you got a lot of people out there saying, oh, I'm a part of a tribe, or the United States recognized my tribe. Okay, can you tell me the name of your judge? Can you tell me the name of the legislative branch of your tribe? Do you have a constitution? You got 3 branches of government? Has that constitution been ratified, deposited, and promulgated in accordance to international law? Meaning you have to deposit it, right? Register it with the United Nations in accordance with Article 102? Well, the answer is no. 9 times out of 10, they're going to tell you, nah, we ain't got none of that. We just got a tribe. We just doing our Indian thing. So, okay. So you're saying the Cherokee Nation didn't recognize you because you heard what the United States said they only recognize the 5 civilized tribes. Don't get me wrong, it's all kind of tribal nations. But if the United States don't recognize your reservation, your tribe, then you ain't got nothing coming. And you still come under their jurisdiction, and you come under the jurisdiction of that Indian tribe. So black people, you ain't running away from no jurisdiction. Your behind gonna get adjudicated in the jurisdiction of the United States, or you gonna get adjudicated in the jurisdiction of an Indian tribe. Jurisdiction is just jurisdiction, but somebody's going to govern you. So you can put on all the feathers you want to, but when you get serious, find out who the judge is. That's when I'm going to know you're serious about being Indians. Ask them, where's the laws? Show me the book of laws for that Indian tribe, that Indian reservation. Say, can I see all the statutes and laws and codes and ordinances of this tribe? You got some laws that I have to abide by. What happens if I break these laws? Who's the name of the judge? You see what's happening? Okay. Listen. You got to understand why they're talking about tribal courts and federal courts. It's all about courts to maintain what? An organized dual society of laws. Somebody got to enforce the laws. So if you claim to be an Indian, but you ain't got no courts, then you're just doing something that's called Mickey Mouse. It's play. We got to grow up as a people. Listen. We're talking statehood. We're talking statehood. We're talking external statehood, internal statehood, or is it integration? What's your status? Because all three of those statuses should have three branches of government. Okay? All right, so I got a questionnaire up here. Let's get into this more. Okay, no.
Who has original state jurisdiction over the territory? A list of powers regarding layers of jurisdiction. Empire State of Morocco for Moroccans. That was number 1. Empire State of Morocco for Moroccans. The empire is void of a sitting head of state.
Pause. Okay, so you see how I got this numbered, Morris? Right here I got it numbered based upon what? A list of powers regarding layers of jurisdiction. So the highest status of jurisdiction, subject matter jurisdiction, the power of law and the power of courts starts with number 1, the Empire State of Morocco. Okay, let's start with number 1 again, though.
1. Empire State of Morocco for Moroccans. Empire is void of a sitting head of state. 2. Provincial Moorish state governments. Mogsans, example, AMPAC. 3. Wazir Regional Council, the intergovernmental organizations of the Moorish Empire. 4. Foreign United States of America. USA is void of a sitting head of state. 5. Foreign United States, the intergovernmental organization of the USA. 6. American Indian reservations. America was established in 1507 by M. Waldsee Muller.
Yes.
Map. 7. Foreign several union chartered states of the United States Federal Corporation.
Okay, so in sequential order, this is what you call subject matter jurisdiction. Who laws is above your laws? Who's under your laws? And according to treaty law, right? Treaty law. Okay, hold up. The treaty law. In the case of France versus United States of America, it got exposed that what? The United States of America is in Morocco, so Morocco has the subject matter jurisdiction. Then the United States of America is second, you see? Second. Listen. So therefore it starts like this. We're talking jurisdiction of territory, so it's in layers. Okay? Let's say, let's use AMPAC as an example. Matter of fact, let's use Oklahoma. Fair enough? Since we just looked at a case of Oklahoma. Let's say the Moors established a state in Oklahoma. That now that Moor state, right, it says it's Ante, Oklahoma. Okay, it's a Moor state now. It's got a constitution, etc. Okay, so what happens? Okay, so that Moorish state recognizes the Empire State of Morocco for Moroccan, so the empire has the ultimate jurisdiction, right? But the empire right now is void of a sitting head of state. So by default, what happens next? Now the Moorish government ends up now having the power of subject matter jurisdiction. Because the Empire of Morocco is void of a government for now. No sitting head of state. Okay? So you got the provincial Moorish state government, the Moslem, for example, AMPAC, but we're going to say Ante, Oklahoma. It's a Moorish state government. that now has the subject matter jurisdiction of its laws and its courts, and everybody comes under that ante Oklahoma Moorish state, including who? Right? The Wazir Regional Council, which is an intergovernmental organization of the Moorish Empire. So therefore, the Moorish state governments have created a regional council called an intergovernmental organization. But organizations do not have more jurisdiction than states. But yet states can operate through intergovernmental organizations. It is states that give organizations power. Organizations don't give states power. Okay? Only states can give organizations power. Okay? So, who comes under the Wazir Regional Council and the Moorish state government and the Empire of Morocco? Well, that would be the foreign United States of America. However, the United States of America is a legal personality on the contracts. The United States is void of a sitting head of state. There is no president of the United States of America. Right? So it's in a shallow gray. Number 5. The foreign United States comes under the jurisdiction of the United States of America. But the United States of America is in Morocco, so therefore the United States of America comes under the Wazir Regional Council, and the United States of America comes under the Moorish state government. Right? The United States of America comes under the Empire State of Morocco. All these are jurisdictions. However, the United States of America is over the foreign United States. So the United States comes under the jurisdiction of the United States of America. Number 6, it says American Indian Reservations. So American Indian Reservations come under the jurisdiction of the United States. You see that? And last but not least, the foreign several union charter states come under the jurisdiction of American Indian Reservations. But wait a minute, pause right there. Can Indian reservations bring citizens of the United States into an Indian court? The answer is no. The Indian reservations are autonomous away from any Americans. But Indian reservation courts don't have no jurisdiction whatsoever to prosecute an American whatsoever. However, when I'm talking jurisdiction, these American Indian reservations have a higher status than the charter states. But when we're talking courts, Indian reservation courts have nothing to do with Americans. However, Americans want to sue Indians, they have to go and take it to the United States federal courts. You see? That's what the Indians have to do. They have to bring their dispute against an American into a United States federal court. All right? Why is that? Because they're operating like two separate states. It's state on state dispute. So who becomes the referee? United States. Just like with Moors, we have our Moroccan states, and then you're dealing with the United States of America. Well, who becomes the referee between the Moroccan state and the American state? It becomes consul court. You see? Same thing happens with the Indians and the Americans. They got to go to the United States. You see? Listen. All right, let's move on. Check this out, Morris. Okay, we got to go through this. We're talking about internal and external, right, and integration status of states. Okay, who has jurisdiction? This is important to understand. Listen from the top, Brother Dre.
Subject matter jurisdiction of state laws and courts, a list of powers regarding layers of jurisdiction. 1, Moorish Consular Court, the Moorish question. Number 2, United States Supreme Court, the federal question. Number 3, Indian Reservation Courts, the Indian question. And 4, Union Charter State Courts, the Union State question.
Okay, this is all about the question. Right? More study enough, they know about this thing called the federal question. Right? What's the federal question? It's all about the question. Right? What's the question about? Jurisdiction. Who has jurisdiction? Right? Commonly known as supplemental jurisdiction. Who gets to supplement the jurisdiction? Who has first dibs of jurisdiction? Who gets to prosecute first? Right? Who has supreme power to adjudicate? Okay, so here's the list from the top. Subject matter jurisdiction of state laws and courts. So whoever has the subject matter jurisdiction gets to invoke their state laws and their state courts. You see that? So right here it says a list of powers regarding layers of jurisdiction. These are layers, okay? So if these were Moors of Ante, Oklahoma, if they was all sharing that same latitude, longitude as layers, Ante, Oklahoma, Moore State, will have the supreme jurisdiction over all these legal personalities. You see that? Ante, Oklahoma, as a Moore State, will have the supreme jurisdiction of courts and laws over all these personalities. You see? Listen. So it's called the question. So when two disputing parties are disputing, they say, okay, well, who has jurisdiction? It becomes a question. Right? So the first question is, okay, Moorish Council Courts, it's called the Moorish question. Right? So if a Moor gets caught up in a dispute with a foreign state, then it becomes the Moorish question, because Moors have the supreme jurisdiction, because everybody's located where? In Morocco. Mm-hmm. That's called original jurisdiction. And subject matter jurisdiction. Based upon the same territory of what's commonly known as Oklahoma. Guess what? If that Oklahoma is a square, now you got these different layers of jurisdiction over that same piece of land. It's layers. So the question becomes, who has the jurisdiction to drag that dispute into a court to use that court's laws? So therefore, we get to use our consular court to enforce Moroccan laws over all these legal personalities, such as the United States Supreme Court, which is the federal question. The Supreme Court is subordinate to consular court. The Indian Reservation Courts, which is the Indian question from McGirt, says now the Indian question of Indian Reservation Courts are subordinate to, inferior to what? The United States Supreme Court, and the United States Supreme Court is inferior under the consular court. Then based upon these layers, the Union Charter State number 4, their court, which is called the Union State question, their jurisdiction now is under who? It's under the United States Supreme Court, and the Charter States jurisdiction is under the Moorish Consular Court. Everybody's jurisdiction is under consular court. You have to understand this is in layers. It's talking subject matter jurisdiction. Okay? Listen. No.
A list of powers regarding nationality. 1. Moroccans, de jure name in the Empire of Morocco. 2. Americans, foreign colonial name in Morocco. 3. Lenapes, etc., capitulation name in the United States.
All right, so here's a list of powers regarding nationality. Power what? Law and courts regarding a nationality. So when you say your nationality out loud, people automatically know, do you have supreme jurisdiction just by your nationality alone? Okay, so these are 3 nationalities. Okay, so number 1, Moroccan as a nationality. So Moroccans is the de jure name in the Empire of Morocco. And it has the de jure powers of consular court and laws, Moroccan laws. Number 2, American as a nationality is a foreign colonial name in Morocco, right? Because the United States of America is located where? In Morocco, you see? Mm-hmm. Number 3, Lenapes. Well, Lenapes are the first ones to sign a treaty with the 13 colonies, 1778, around September. But however, it's still a capitulation name. Lenapes is a capitulation name in the jurisdiction of the United States. They have subjugated themselves. They accepted their subjugation status under what's called capitulation. All right? So under your own nationality, it immediately tells people, you say you're Moroccan, they know that you are the supreme being in the land. When you say you're American, all the Americans are finding out they come under the jurisdiction of Moroccans, Moroccan law. And anyone call themselves an Indian, well, you come under the jurisdiction of the Americans under what's called capitulation, right? Okay. What's the definition of capitulation? Brother Dre?
Capitulation, noun, the action of surrendering or ceasing to resist an opponent or demand.
All right, so capitulation means noun, the action of surrendering or ceasing to resist an opponent or demand, right? Similar, surrender, submission, yielding, succumbing, acquiescence. You see that?
Mm-hmm.
So the Indians have capitulated to come under the jurisdiction of the United States through their treaties. Regardless of your prima facie, whether this was a pale-faced Indian or a dark-faced Indian, Indian is just Indian. So you got to understand, you choose to be Indian, you come under the jurisdiction of the United States. However, you choose to be Moroccan, that's the highest status in the land regarding the society of statehood. Moroccans have what's called external jurisdiction of courts and laws. Indians have internal jurisdiction, they're subordinate. However, the United States of America has integrated with the external SARS. You see what's happening? So this is all in layers right here. You got to understand. So when we start dealing with states, we got to know who has seniority and who don't. Who's superior, who's inferior. Listen. What are the basic elements to a contract? Okay. No.
There are 4 basic elements of a contract between parties. 1, the parties must be known. Moroccan state versus American state. 2, who's superior or who's inferior. External state law versus internal state law. 3, terms and conditions. Definitions of words and the articles of the contract. 4, how to enforce the contract. Mediation, arbitration, adjudication, and /court.
Right, okay. So there are 4 basic elements of contract between parties. So if you're talking contract law, how do you enforce a contract? Well, in every contract, a contract is either bilateral between only 2 parties, or it's multilateral. It's got 3 or more parties. Okay? So in a contract, i.e. a treaty, this is what everybody must understand based upon the basics, the basic elements. Okay? Number 1, the parties must be known. So in our Moroccan treaties, is about the Moroccan state versus an American state, right? So that's what our parties' names are in the treaties, Moroccans and Americans, right? But the Moroccans have the original jurisdiction because the United States of America is located where? In Morocco, right? Number 2, in the same contract of a treaty or a regular contract, you need to know who's superior or who's inferior. The parties must be known. So it's about who's the external state in their laws versus the internal state in their laws, right? Or the integration states, such as the United States of America. We integrated with them. Well, since the United States of America has integrated with Moors, now you come back up here and you still understand that the Moroccan state still has a superior position with Americans. But we absolutely have jurisdiction over any reservations and the several union states. Right? Listen. Now, number 3 in contract law says, now you must understand terms and conditions. Okay? So what are terms? Terms are the definition of words. But when you understand the definition of words, that sets up the conditions of the articles of the contract. Now you get into the subsections, etc. Now that you define the words. Now you get into Article 1, etc. and read on through it. That sets up the conditions, right? Set forth. Okay? Number 4, how to enforce the contract, i.e. how do you enforce the treaty? Well, first you start with mediation, then arbitration, and if mediation, arbitration fails, then adjudication must prevail through the court. You see? I.e. the proper venue. Where they'll ask the question, whose court will you use? Oh, now you come back up to find out who was what? who was superior in the contract. Whoever was superior gets to use their jurisdictional court and laws. So now you scroll back up, now as you understand the 4 basic elements of contract law, and understand Moroccans are first, Americans are second, because the Americans signed off on these Moorish treaties, right? Now you scroll back up based upon nationality, Moroccans have a higher status in the contract, right? Based upon nationality. That's why the Moors needed to know the proper nationality, because you can't have a higher status of Americans when you call yourself Moorish American. Because Moorish Americans are adopted, naturalized citizens of the United States. You're stateless, or at the very least, you're naturalized as citizens of the United States. Either way, you ain't got no power. This is important. So the Moors got to stop calling themselves Americans and start calling themselves Moroccans. You know what Raleigh say that? Don't get me started. Let's continue. All right. So when you understand the 4 basic elements of a contract, now you understand your Moorish consular courts, because the Moors are what? Moroccans.
Yes.
The word Moors in etymology dictionary is an adjective. So Moors, if Moors is an adjective, what is it describing? It's describing what? The Moroccan. It's like someone who comes from Britain is British. British is an adjective to describe the noun, which is Great Britain, because Great Britain is the noun. Mm-hmm. It describes the people coming from a jurisdiction. So Moorish, Moroccan consular courts. It's about the Moorish question when Moroccans have a dispute with anybody else in our jurisdiction. Not Moorish Americans. Moorish Americans are down here under the Supreme Court and the chartered state courts as naturalized citizens, i.e. the Americans. You gotta understand what's happening here. I'm talking jurisdiction. Jurisdiction is all about the name you call yourself. You say you're the true American, guess what? You down here dealing with these state courts, and you down here dealing with these Supreme Courts, and you wonder why they're adjudicating you. Because you keep saying you're American. This is shameful. Listen. So now as you understand the 4 basic elements of a contract, now you start understanding who has original state jurisdiction over the territory. Mm-hmm. This is too easy. So now you understand these 7 statuses of who has original jurisdiction, and subject matter jurisdiction is the Empire State of Morocco for Moroccans. And also our provincial Moor state governments, the Mogsans, have jurisdiction over all these statuses. That must be understood. Okay, listen. Here's the Act out of Sarah's of 1906, a multilateral treaty. What type of treaty? Moorish treaty. Yep. Parties must be known. So soon you scroll down, it immediately starts telling you in Articles 1 and 2, immediately it's going to tell you who has jurisdiction. Okay. Article 1, Brother Dre.
Declaration relative to the organization of the police. Article 1. The conference summoned by His Majesty the Sultan to pronounce on the measures necessary to organize the police declares that the following provisions should be made.
Okay, so the Sultan's ran in order. He's taking jurisdiction over all police. Police are part of what? The judicial system, right? And the judicial system also oversees what? Laws and courts. So the Sultan ran in order to allow who to run the territories? Moors to be the police and the prosecutors and the judges. Okay, Article 2 starts to talk about it.
Article 2. The police shall be under the sovereign authority of His Majesty the Sultan. It shall be recruited by the Mogzin from Moorish Mohammedans, commanded by Moorish Cades, and distributed in the 8 ports open to commerce.
All right, keep it in mind. We're talking about sovereignty of authority, right? What type of sovereignty, though? Independent sovereignty, not dependent sovereignty. You're talking external statehood, not internal statehood. You got to see what these treaties are talking about, okay? All right.
Article 3. In order to aid the Sultan in the organization of this police, Spanish officers and non-commissioned officers as instructors and French officers and non-commissioned officers as instructors shall be placed at his disposal by the respective governments, which shall submit their designation to the approval of his Sharifian Majesty. A contract drawn between the Moxen and these instructors in conformity to the regulation provided by Article 4.
Paul, so the contract drawn up between the Moxen, who's the Moxen? The Moorish state government, and these instructors. Who's instructors? The Spaniards and the French. So the Moors supposed to be signing a contract with the Spanish and the French back in 1906 because it was the obligation of the French and the Spaniards to teach the Moors to get back into sovereignty to start running the Empire of Morocco again. Keep in mind, this is 1906. The Moors have been colonized for over 100 years, if not 300. You see? Had to train the Moors to start governing again. You see? The Sultan wanted the French and Spaniards to do this on behalf of the Sultan to help the Moors get back into governance. All right? That's the Moxen in a contract, right, between the Moxen and the Spaniards and the French. Continue.
Shall determine the conditions of their engagement and fix their pay, which must not be less than double of the pay corresponding to the rank of each officer or non-commissioned officer. In addition, they will be allowed living expenses varying according to their residences. Proper lodgings will be placed at their disposal by the Moxen, which will likewise supply them with their horses and necessary fodder.
Paul, so the Moxen, the Moorish state government is providing the French and the Spanish with everything they need. Right? So the Sultan and the Moors are working side by side. Right? But they need France and Spain to train the Moors how to get back into true sovereign authority. Sovereign authority. Listen.
The governments having jurisdiction over the instructors reserve the right to recall them and replace them by others, accepted and engaged under the same conditions. Article 4. These officers and non-commissioned officers for a period of 5 years to date from the ratification of the Act of the Conference shall give their service to the organization of a body of Sharifian police. They shall assure instruction and discipline in conformity with the regulations to be drawn up in respect thereto. They shall also see that the men enlisted are fit for military service. In a general way, they shall supervise the administration of the soldiers and superintend the payment of their salary, which shall be effected by the Amin, assisted by the accounting officer instructor. They shall extend to the Moorish authorities invested with the command of these bodies their technical aid in the exercise of the said command.
All right, so the Moorish authorities, right? It's all about extending to the Moorish authorities because they're training the Moors to get back to authority status. They're learning how to be soldiers and have the authority to oversee the police. So therefore, if they're controlling the police, that means they're controlling Moroccan law. They're enforcing Moroccan law as police. Then you learn later on about also the consular court. Moors sit in the consular court. So it's all about the Moorish government. Okay, hold on. Okay, let's look at Article 15. All right.
Article 15. The arms, parts of guns, and ammunition intended for the troops of His Sharifian Majesty will be admitted after the fulfillment of the following formalities. A declaration signed by the Moorish Minister of War describing the number and nature of such articles ordered abroad must be presented to the legation of the country of their origin, whose visa shall be affixed thereto.
All right, so it's all about the Moorish Minister of War. These are Moors overseeing now the military and the police. You see? Continue.
The passage through the customs of the cases and packages containing the arms and munitions delivered at the order of the Moorish government shall be effected upon the presentation.
So it's all about the Moorish government. You see that? The Moorish government is overseeing arms in the military. You see this? Keep in mind now, Moorish means what? What does Moorish mean? Okay. Moorish means what? Moroccan, right? You see it right here? Moroccan. All right? Now we learned in class 117, Moroccan, M-A-R, right, was translated into what? M-O-R, and it turned into Moroccan, right? It just changed the first vowel of the A. But it's semantics, right? Synonyms. Moroccan and Moroccan is the same in international law because this is an international law treaty with both statuses of Moroccan and Moroccan, right? It's about the Moorish government. So the government was supposed to be overseeing the empire of Morocco, right? The empire, going back up, it's all about the empire, right? We learned this. We learned this when we started looking at all the titles and what were the obligations of the Moors. Well, the Moors were obligated to oversee the empire according to chapter 5. Read that for me, Brother Rick.
Chapter 5, the regulation concerning the customs of the empire and the repression of fraud and smuggling.
All right, so it's all about the empire, right? Then the Moorish government is now governing the empire. You see that? Okay, now you go back to my list. So the empire state of Morocco, the empire, is being governed by the Moorish state governments, i.e. the Mahdi. You see how easy that is? According to what? Treaty laws. This is why the Europeans are studying to get an understanding of, okay, what rights do these Moors have in self-determination? Because they say, best case scenario, let's try to convince these Moors to either remain being black or get them to say that they are what? Indians. You see the games being played? Because they know they can't stop your self-determination. But the name of the game is try to get these black people to say they're Indians instead of saying that they're Moors. Because they say they're Moors, now they get to invoke what's called external self-determination to run the empire of Morocco through their Moorish state governments. I end with that. Islam.
Islam.